Judgment in the appeal, Michalak and General Medical Counsel and others.
Lord Kerr will explain the decision of the court.
Michalak is a doctor. She was employed by the Mid-Yorkshire National Health Service Trust from April 2002 until she was dismissed in July 2008. Following her dismissal, Dr. Michalak brought an unfair dismissal claim against the Trust in the Employment Tribunal. The Tribunal found that her dismissal had been unfair because of sex and race discrimination and victimisation. Dr. Michalak received a compensation award and a public apology from the Trust. But before the Tribunal had made its decision, the Trust had reported Dr. Michalak to the General Medical Council to consider whether she should continue to be registered as a medical practitioner. The GMC began what are called fitness to practice proceedings against her. She claims that the General Medical Council discriminated against her in the way that it pursued those proceedings. She also says that the discrimination extended to a failure on the part of the GMC to investigate complaints that she had made against other doctors employed by the Trust. In August 2013, Dr. Michalak brought a claim in the Employment Tribunal against the GMC and also against its chief executive and one of its investigation officers, and that related to the discrimination claim that she promoted. The General Medical Council argued that Section 120, subsection 7 of the Equality Act 2010 meant that the Employment Tribunal did not have jurisdiction to hear her claim. That subsection provides that where a person has a right to appeal a decision or to take proceedings in the nature of an appeal, she or he should not proceed in the Employment Tribunal. The GMC said that Dr. Michalak could have made a judicial review application, and by that judicial review application, she could have challenged the way in which the GMC had pursued its fitness to practice proceedings. The judicial review proceedings were, the GMC said, in the nature of an appeal. The Employment Appeals Tribunal accepted that argument and struck out Dr. Michalak's claim. She appealed. The Court of Appeal upheld her appeal, and the GMC has appealed to this court. This court unanimously dismisses the General Medical Council's appeal. It was accepted, of course, that Dr. Michalak could have made a judicial review application, but this court considers that such an application is not a proceedings, in the words of the statute, in the nature of an appeal. Conventionally, an appeal is a procedure which entails a review of an original decision in all its aspects. An appeal body may thus examine the basis on which the original decision was made, assess the merits of the conclusion reached, and if it disagrees with those conclusions, to substitute its own view. By contrast, judicial review is a proceeding in which the legality of or the procedure by which a decision is reached is challenged. It cannot partake of the nature of an appeal. The remedy on a judicial review application in circumstances such as the present is a declaration that the decision is unlawful or that the decision should be quashed. The court cannot substitute its own decision for that of the decision maker. Here, a claim for judicial review would not allow the decision of the GMC to be reversed. An appeal in a discrimination case must confront directly the question whether discrimination has taken place, not whether the GMC had taken a decision which was legally open to it. That was not possible under judicial review, and that was the principal reason that the appeal is dismissed. But there was a second reason. Section 120, subsection 7, also requires that the proceedings in the nature of an appeal must be available by virtue of an enactment. This court decided that judicial review did not come within this rubric. Although Section 31 of the Senior Courts Act 1981 regulates the way in which judicial review applications are to be made, the origins of judicial review lie firmly in the common law. Section 31 did not establish judicial review as a procedure, it merely prescribed how such applications should be made. For that reason also, the appeal is dismissed.